in a local one, that I think there are solutions as such.
Okay, great. For time's sake, as you know, first of all, a big thanks to all the speakers. Don't leave. Also the ones online, do not log off. We now have the networking part. So if you turn on your camera and keep room, it's sort of a self-explanatory. If it's not, please use the chat. But this is a point where you can actually go and reach out to the people that you found either very interesting from the comments or very interesting because you looked at their profile and you want to engage with them. So it's the part where normally we would get up and get a drink or a sandwich. You're going to have to help yourself online. I'm thanking Trevor. Good to see that you got your drink with you. We have a bit of water here too. So cheers to everybody. Big thanks to all our speakers. They will join you for networking event afterwards. And a last practical announcement at 5 o'clock, we're going to do a little test. It's a little bit cynical on Clubhouse, a very popular app for people who have iPhones. So the privacy is a nightmare on there on this app, but it's an audio only app. It's free and open. So if you want to chip in or test it out, you can go. The link is there on the Clubhouse. It's like you have to imagine it being a podcast where you can live come on in the audio stream. So it's a very open and very nice format to test with, I would say. So that's at 5 o'clock. We continue, and now you have your networking. Thanks to all our sponsors. Thanks for all of you being here. Take good care of yourselves and see you for our next event. Bye-bye.
Thanks, Jay.
Hello everyone, I invite you to put your camera on the left corner of your screen. You can click on in the micro and then you can click live close to your name. I will put Peter live. I have Vincent live, Edwin from live as well. Hello everyone. Happy to see you.
Hi everyone.
Hi.
Hi.
Hi there.
Good afternoon.
So we are waiting for the other one. So we see that In is there, Lord. I invite you to put your camera and micro on, like that you can join us live. There we go. We have Patricia live. Hello.
Hi Patricia.
Hey, Patricia.
Great. Don't worry, speakers are coming. You will be able to ask your questions. We see that Lorian is already connected.
I don't know the others, but I didn't have the live button. It was just...
It just happened.
Yeah, indeed. So it's Caroline who's actually activating us. Yeah. Thank you, Carol.
You're welcome. Hello, In.
Hi.
Happy to see you again here.
It's my subject.
So, what do you think about this meetup?
That we are looking for what, a real meetup with a real glass of white wine or something? I'm bored with all those meetings, screen meeting, really.
Yeah.
Spring is coming, they say.
Exactly. And with the immunity and this virus.
Yeah.
So I think we have other one there. Louise, could you put your camera and microphone on? Load as well. There we go. We have Lorian, a nice speaker of the day. Jean-François is coming as well. Okay, maybe what I can suggest is to make a short introduction of yourself, like that we know with who we are talking, and we can start. Maybe
I would
Trevor.
Yeah, I would suggest that Jean-François starts, because Jean-François is actually the RecTech ambassador for FinTech Belgium, as you might know, and actually the whole meetup of today, he's the one to have worked and put all these really good speakers together with Caroline. So a big applause to you. It was really interesting. So thank you all of you. And maybe you can introduce yourself a bit further.
Yes, thanks. Jean-François Erin from Vedis Technologies, just leading the RedTech vertical at FinTech Belgium. Thank you to all of us to being there. Yeah. I don't know who can continue. Maybe Vincent?
Yeah, so Vincent Mercenier, I've got two hats in this FinTech meetup. I work at Byway, which is a card issuer. So the question of mixing databases of card issuer and retailers. And for 1 month now, I am on the board of Pay Belgium, so representing the non-bank payment institutions. So I give maybe the word to Ine.
Yeah, let's see if I can get my microphone.
You know, if you want to restart your camera on and off, it might solve the problem of your image.
No, I think it's better.
Okay, on my side it's still turning.
I know we have him.
No, it's fine.
We can see you.
Okay. So I'm a PhD researcher. I'm looking into personal data protection and the financial.
You can go next.
No, Alice, it's okay. We can hear perfectly and see perfectly in.
Not here.
So
Sorry, in. You can go.
I'm a PhD researcher looking into data protection practices in the financial sector. And I hadn't heard so much yet about Schrems 2 and the consequences of that. So it was very interesting to me.
Okay,
Okay,
well
great.
then, let me.
Go ahead, Edwin.
Yes, hi, good afternoon all. So my name is Edwin Braam and I represent Thales Data Protection, which is specifically about encryption and key management. So we are almost in the middle of a Schrems 2 swirl, which is all over the companies trying to figure out how to protect their data. So this was interesting today, also a confirmation of what we already see, what multiple companies are facing. And well, nice to meet you all. Curious on how this discussion will go and what questions will be raised. Next.
I'll maybe go while we wait, and I suggest that each person that is finished presenting points to another person who hasn't presented themselves yet, so that way things keep going. Putting off my moderator role here, putting on my entrepreneurial hat. So my day job is at data.be. We process a lot of company information, but actually we process an enormous amount of private information too under a legitimate interest approach, where we actually define from the bylaws of companies which persons can represent which company with which mandate. So if they can sign a loan and up to which amount, and we use the authentic bylaws for that. So it's text mining, but saying that, it means we did extract a lot of private information from those public texts. So it's a weird case that protection officers really look at it often a bit in surprise when we first need to educate them about how we got the data, and we have to often reiterate the concept of open data and the PSI Act under which governments open this data. So we use them for the purpose for which they are opened, but even then we do have a lot of private information. So all of you are entrepreneurs, we have your first name, last name, address, all that sort of stuff, and you did not consent to me directly, to make it very clear. Welcome to my world. So I'm on the receiving side of getting data subject removal requests. So I've been doing that for 8 years. I'm violating my own suggestion already. So Patricia, please go ahead. She's a fellow board member, so go.
And you're still muted.
Thank you, Toon. So yeah, for those who don't know me, I'm also board member and vice president for FinTech Belgium and the InsurTech ambassador. And as from the start from PSD2, I'm also a big ambassador, not for PSD3, but I do want to have open banking or open finance one. I do hope that we will get that legislation. I plead even this morning for the EU Commission on that, because open data will drive innovation and will give many more possibilities than we now see at PSD2. But of course, with all the GDPR, privacy and other legislation, it is a very, very, let's say, challenging topic to bring all the puzzle pieces into one big shared open data by API gateways. So I do hope in the following years that all the players in the financial services industry will be capable to put down that puzzle, and that the EU legislation will also cater for that, and that everybody can benefit also for the of open data, and not only look at the threats, but also, of course, look at all the possibilities that it will bring along for the for our clients, for our customers. That's what I wanted to say. And I point Peter. He's also a board member, so we just keep it, and then we can open the discussion.
Thank you, Patricia. I'm not formally a board member yet, because it will be. It will come in the month of April. So yes, I'm engaged with Accounting Tech, because I'm the co-founder of an accounting tech company. We have launched a product called Okioki recently, where we have a lot of company data as well in a SaaS solution. So where we are actually harvesting, or it's a bad word to call it harvesting, but it is like that. We allow an entrepreneur to connect his data stores, like his Cloud Drive, Google Drive, or OneDrive, and his email box, where his invoices come in, and we will automatically get those invoices from there, OCR them. And as we are also a PSD2 licensed account information service provider, we link those documents to those transactions. So the entrepreneur we are helping the entrepreneur to understand whether he's up to date with his documents and the things that he needs to deliver to his accountant to make sure that his VAT submission and other compliance submissions that are necessary can be done without him having to scramble at the first Sunday of next quarter to get everything together for his accountant. So we are actually automating the financial administration work for the entrepreneurs and helping accountants a lot, because their business is also digitizing, but a lot of their customers aren't. So we are actually helping them in getting their customers onto a digital way of supplying information to them. That's about it. And I point to Wim Simons.
Yeah, good. Hello, everybody. I'm Wim Simons. I'm an independent internal audit and risk consultant, expert, whatever you want to call it. I advise people on internal audit, risk management. I'm internal auditor for some companies, also did some risk assessments. I'm not a pure GDPR expert, but GDPR compliance is, of course, covered by my Audit Universum. At the moment, I'm auditing or helping a fintech company on GDPR. That's why it's actually very interesting. Not only Scrums, but I find just the GDPR in general. I'm now at the moment, it's a UK-based company, and a discussion whether they need a DPO, yes or no. Regulations is usually very, very vague. It usually is one sentence that you can, how they can say, it's quite open for interpretation. And I'm quite convinced that they process data and that they need a DPO, they not so. So that's why I find it very interesting to listen what everybody had to say today. You could hear me, yes? Ah, okay, sorry. And I point to, I guess, I don't know who didn't.
Louis.
Louis, thank you.
Hello guys. Okay, so my name is Louis de Vauvrin. I'm a co-founder of different projects actually, and one of them is called Data Broadcaster, and we actually provide a tool to broadcast your data in a structured, secured, and encrypted way, leveraging on Excel, meaning most of the small to medium businesses are still dealing and managing the data via Excel, and we help kind of empowering Excel to transform it in a tool that allows to transfer data in a smooth way, but with the encryption capacity and the security added. And obviously, I mean, all the topic around compliance data is it makes a lot of sense for us. So it's a kind of obvious use case. We have different customers already using our tool for their specific needs around compliance data. So I was a bit curious to understand a bit more all these questions around the legal framework that GDPR is pushing a very clear direction onto how the data must be managed in such a way. So that is it. We can jump to the next one. I'm not sure who has not talked yet. Maybe Frédéric or I don't know.
Yes, thank you. So I will do it briefly. So hello everyone. So Frédéric, working for co-founder of Data Village. Voilà, nothing to say. I think I already shared everything during the presentation, and quite happy to see some people. I would say usual suspects. So hello in, as usual. I would say hello. Voilà.
Magali, it's for you to add a little bit more what Ananos does, because you've done your pitch already. So this is the moment where you are allowed to sell your services.
Indeed, it's well. I think I already mentioned in during the presentation. It is really a software tool, and it's a tool that really can help with doing what Schrems 2 is requesting. Is those secondary or supplementary measures, and one thereof also approved by the EDPB is use case 2, is when you have to transfer data and use data with, for example, the US, is to pseudonymize that data, but GDPR compliant pseudonymization. And I think the real benefit of the solution is really the fact that you can create use case specific pseudonymization. So you can really control if your data is being structured and labeled. Because why I also say labeled is because there are also, for me, other like IP rights, contractual restrictions maybe that are on the data. There's not only GDPR, luckily. And then you can, from that data lake, which, for example, can be encrypted, can be protected with a number of safeguards, but from that data lake, whenever you have a specific use case, you can use the tool and create a data set where the identity is really separated from the information value, what you need for your use case, and really use that data really for business analytics, training AI, for doing advertising. And so the one time you will create micro segments and you only need to say, oh, we need gender, we need to know in a sort of income, we need to have this or that. But in other, for example, AI training, you will need a lot of data, and the solution is actually enabling that. And one of our first clients is actually a bank who has a lot of trouble saying we have those, we're actually sitting on a pile of data, but we cannot use it because we don't have the consent or on other legal grounds. We think there is legitimate interest, but legitimate interest, in order to balance the interest at a third test, you need to have pseudonymization, or pseudonymization can really help to balance that interest, and that is what Ananos is providing. Thank you.
there is 7 minutes left. If I may add one point, Tony, you talk about the irony to have this drink later on this afternoon on this marvelous platform, social platform. We don't know if the CNIL will allow us to chat at 5 o'clock, but a double irony is spending a lot of time to speak about privacy and information security, and we spend a lot of money on that point as well. And the irony is that doing that in Belgium with how we see about the government and the ADP having their own issue with the privacy of the citizens of Belgium. So, kind of.
I think it's very interesting point. I hear there's some feedback here. I think something else is still open here. Putting in a header because I think there's another device here that is relaying into the chat. I hope you can hear me now. I actually had two questions. First one to Wim, what did you learn? Because you're advising a customer, you are clearly very well aware of all these things. What was for you something new, or if you didn't learn anything new, what is the question you have for any of the experts on this in this group? And then my follow-up question would be to others who have contacts with, I would say our regulatory privacy authority, the GBA, on how they feel. I would say the fact that there's no real teeth there and no real unity in their decisions. So first one to Wim.
But it's not so much Scrum related. It was more to DPO. Just the question: when do you need as a company a DPO? So you need it when you. It's actually the rule. Just said one sentence when your core activity is processing personal data. In this case, it is. I'm still busy. I'm still. I'm doing it next month, so I'm still do the assessment next month. So I didn't at this point learn much, but when I know what they're doing, I was very surprised that they didn't have a DPO. I did a consultancy before, also with a UK fintech, and they had a DPO in UK and also one in Belgium. So I was just surprised. So for me,
I can just tell you that you don't always, I mean, the DPOs won't like the answer, but in a small company like mine, there's only 8 people. I'm the DPO. So I have the CEO DPO hats.
Yeah, but it doesn't. It even doesn't matter if the janitor does it. It is just the fact. If you need it, you also have to be registered with the agency. No, it's not just I'm doing the DPO. You also it's not.
No, you just have to put a person there to who is the primary contact, the SPOC, if there's any questions.
And you have to communicate.
Person should be knowledgeable.
You have to communicate this to an.
Yes. So as a company, we did register towards that we process a lot of data, and my name is on there as a person to contact. But there's no. I'm also the janitor probably, so I don't take that badly. In a small company, you do it. It's one of the new roles. But I know that when we speak to legal professionals, they of course would like to have a formally trained, certified person in that role.
Yeah. But it's indeed at the moment very. It's seen as so important, and there's so much legislation. But you say it yourself. Most companies I saw, it was just a title. It was usually somebody who did finance or the IT director. So at this point, it's taken serious in a lot of regulations, but in companies apparently not. But the problem is, of course, with smaller companies. You say it now yourself. If it's even below 50 people, you can't have somebody who's full-time busy with DPO. At the same time, what I do notice with most companies is that I'm not going to say that it's not taking serious, but it's not so important. Of course, it's just one small item, a 0.5 FTE that is put on somebody who's happened to be a DPO. Now and then follows.
I would now. Sorry for stopping you. I would invite the people who disagree with that, because it's a very strong statement you make, and we have some. So Magali's putting up her hand, so yeah, that works. So, and I see some other hands. So go ahead, Magali.
Please
Yeah,
do.
I just wanted, and I do completely understand, and Toon, I also understand, because I said next to Ananas, I'm also working as a lawyer. We also advise startups, so we're the first one to say, guys, you're not there yet to appoint a DPO. We created DPO as a backup and DPO as a service, but I just want to make you aware of the decisions of the supervisory authority, because now we, for example, at this moment, we're handling a complaint for one of our clients where the DPO was also CISO. Now, they agreed, well, the inspection service said that DPO and CISO can go together, but they made a serious comment on the fact that the DPO was only working for half time as a DPO and whether that was enough. And so we really see, and they also made a comment which I think is ludicrous, but they even made a comment that the DPO was not yet registered at 25 May 2018, but only in June or July or something. So we are really seeing that they are stressing on that point. So I just want to make sure that you're all aware. I'm the first one to say, and even if it goes against our business, to say, look, you don't always, I do understand in the beginning phase, and it's something in a startup you have to look at, and at a certain point you have to think of including that or putting that package with somebody else. But just be aware that, and it's not to my appreciation always, that the data protection authority or the supervisory authority is not taking that role really lightly. And I think it also didn't help that Proximus, who had a DPO who was internal auditor and quality manager and DPO, did not file appeal with the court of the special court to treat the decisions of the supervisory authority, because they, for me, established a sort of, it established a precedent that you have to be very careful with the role of DPO. So I do understand the concerns, but just making aware that the supervisory authorities are not taking that lightly.
I do think they take size of company and how data intensive your company is as elements. For example, a plumber, they do not expect each plumber to have a DPO.
In the GDPR, a plumber does not need a DPO, but they really look, if I apologize, but I think if you're in FinTech, and yeah, you're treating, or you're even as a processor, you're processing a lot of personal data, you fall under that. The issue with FinTech is that you are treating financial data. Financial data, it's not the special categories of data, because if you're treating that, you directly need to have a DPO from the moment you have special categories of data. But the thing is that you do a lot of data processing, major data processing with very sensitive data. And so it would put you at risk. I agree, Toon. I think the size of the company should be really taken into consideration, but we don't always see that reasoning with the Belgian. Definitely,
for people that need to leave and for timing purpose, you can go ahead.
Just a very, very, very small tone. And when you registered, you send an email. Did you got an email back? Is it one way? You just said, look, I'm from this company.
I did this. So in 2012, it was at the Privacy Commission. It was a form. You threw it. You have to indicate which fields, and then that was stopped. And there wasn't. So I recall, but it's already when the GBA was set up. But at some point, I had to fill in a form, and that's it.
Yeah, that's it. So it's no. So my question is, how do they assess the company? Do they go online?
They only do it on inbound if there's a problem, or they look at the file. That's it. It's self-declarative, to my knowledge. And please contradict me. And so I just, Magali, I thank you, because my new job title will be data plumber, and then I'm solved, because that's what I do all day. I fix and I clean data. So me, no nothing. I'm just a data plumber. I don't need a DPO.
I thought you were a professional singer, Toon. But
sorry?
I would be pleased to exchange further with Magali on that point and share my experience, because it's comply or explain. And I explained to supervisory authorities that I've got a CISO DPO. And because I'm really convinced there is clear overlap between the two functions.
Yes, I think so too.
But it's 1:30 and I have to leave. So maybe see you later on Clubhouse.
If you're on Clubhouse, we can continue discussion there on data plumbing.
Yeah.
Thank you very much, Vincent, and also for your excellent questions earlier on. Everybody who wants to or needs to go, and those who want to stay, feel free. We'll stay 5 more minutes, no problem. Go ahead, Magali, you have the floor.
I just wanted to say, can I cite you in my case before the DPA?
Sorry, I didn't get that. You want to for?
I said, can I cite you as data plumber in my case for the DPA?
Yes, you can cite me. if it doesn't bring me into more problems. So just so everybody knows, of course, we even publish the data on people on our website. Yeah? So we do get regular requests of data subjects who want to be removed. We have a procedure for that, and it's crazy the way this is handled. Because the first question I have to ask is like, send me your ID card. So these are people who want to get removed from my systems, and I have to ask them to send their ID card, which then often is like, I'm going to sue you through the GBA. They file a complaint, and then the GBA explains to them, no, sir, you have to identify yourself, because they need to be sure that it is indeed Frédéric Lebeau who's contacting you to get removed and not somebody pretending to be flebeau@gmail.com. So yeah, welcome to my life.
We understand the complaint. One of the parts in the complaint is exactly that they had to send their ID cards to the verification authentication, and that they didn't wish to do that. So it's very.
I have maybe
to ask, was the conclusion the same, Magali, that they had to send the ID cards, or did they say no, there were other ways you should have used It's Me, or you should provide them with a login mechanism to do that? Because I've heard that too.
Yeah, we are just in the round, so we are preparing our trial briefs now, and so we have to file for the 25th, and then we'll see. So I'll definitely keep you posted, but I definitely also know that it's really also depending on the possibilities. So for example, we are really, if we advise clients with applications, like mobile applications, we really say try to make it in the profile of the application that you can easily, and now one of my clients has done it, that they can say, I want to be removed, the right to be forgotten. And so given that it is in the application, and then they have a system, a layered system, where they keep the data for like 30 days and then 10 more months in a backup system, which is then considered as deleted. But if, for example, somebody else would have used the app, then we still have a way of actually putting the data back. But that is a medical app, so we also are there under, because also there's the big question we have, and we also have been working on the framework for the manual and the digital contact tracing in Belgium. We didn't implement the technology and everything, we just made it GDPR, try to make it GDPR compliant, and everybody is always saying, 30 years, but you have to also, that's one of the things, and I think also with financial law, you also have to look at statute of limitation, because that is mandatory law, and even if there is somebody who wants to say, we want to delete the data, or you have, for example, as a processor, and you are up to a certain number of statute of limitation, it is not because your contract is ending that if you delete the data, the problem is if you are afterwards sued. So it actually a lot of problems. That's why I think putting it in a backup and providing a sort of backup system for such, that is seen as, okay, backup is like deleted data. It can really help. But I agree, it's a lot of implementation you have to do, also from a technical point of view.
I have maybe one question. Do you hear me?
Yeah.
Yeah. It's a very practical question in regard to scams too. Does Google Analytics is under the radar? Because Google Analytics is used by most of the services, and I do believe that all the data, including your IP address, are going to servers in the US. So is it something that companies will have to take care about?
Yeah, I mean, for my part, Frederick, I would say I think absolutely. You know, I'm not a lawyer by any means. I'm a software engineer, but my thoughts on SHREMS are completely yes. And this is part of what we say at Amplify. You heard me in the in the call. That very long supply chain of of applications delivered from the cloud by lots of people, Google being one of them. You have to work your way back down that whole chain to the third parties and the fourth parties and figure out, do any of them have my data in their possession? Are they complying with the legislation? Am I exposed because of that? I mean, Magdalena, you can give us the lawyer's view on it, but I think absolutely.
I can give you the end user view, Frederick. They have announced they will drop IP addresses, so they will no longer use that as part of the fingerprinting and following. So in order to comply, they will drop IP address base, but they will replace it by some other token. So don't worry. It's just because those tokens are not in the legal framework yet, and IP address is like it's like in there many times. So that's the workaround.
And the thing is, you have to know that also before Shrimps, this actually they're already under scrutiny by, for example, the ICO, who actually made an entire investigation towards the whole advertising scene and also with the cookies, and saying that actually the whole real-time bidding and how they do it, and definitely how one of the big players, Google, is doing, is definitely not in compliance. Well, at the time they could still say not in compliance with GDPR, but so yes, it's definitely something they have to think about, and we have taken our Belgian DPA has taken a very harsh and stringent stance on the matter. They already said that because they also did once their litigation against Facebook. They also stated, but I'm not completely sure that that is completely accurate, but they state that even if you are using, for example, the Facebook plugin, you could also be held liable for example, Facebook not treating personal data in accordance with GDPR. So they take that liability very broad and very far down the chain.
Okay, I also have to leave. I will maybe a short note to end. But I just note, to summarize what I find a bit low, that with these agencies, that it's more, they could have a preventive role. You know, if they would be a bit more interactive, it's better to prevent. Now, what you have with the DPA, and it's with all regulators, it's with NVB in Belgium. I had a lot of contact with the FCA also in the UK. This is really incident-based, you know. If nothing happens, FCA, for example, did a big letter about safeguarding, I guess, a year or 2 years ago. Why? Because there were big problems. But it's never preventive. It's the same now with Schrem. I'm sure that it's not noticed because somebody went to court with Facebook. Then it's a bit in the media, but for the rest, I find these agencies are more dormant. You know, it's you just send an email to it, and I understand also the fintech and a lot of companies. Why would you invest in it? It's huge regulation, and the chance that you will ever be contacted is so small. So this is a bit I find it's a lot of work, and the end result that could prevent actually where it should be designed for is to prevent that data got lost, prevent that data is misused. This is not usually not done. So this is a bit how I see it on GDPR, but I'm sure with Shrimp it's also not different. Okay, maybe in some big companies, maybe they for big companies they do it a bit more in preventing and are already looking up. But for smaller companies, I can understand that it's maybe not so interesting to invest a lot of money in it.
If I may, I do understand that, Wim, and we've seen that, and that's, for example, why I would hate to say, and it's a true belief in from me personally and in my company, that I do not want to do GDPR just to avoid penalties. I think it's honestly a negative exercise, which costs a lot of money. What I have seen by doing my research on secondary use is that data utility, you want to have that. You want to also create trust as a processor. If you have to go to a controller, it will speed up the whole sales pipeline. If trust towards your direct users is also very important. I think it goes much further than privacy, because I don't think they care that much, as Frederick already pointed out, to privacy all that much. But trust is a whole other thing, which also for me embraces privacy. And if you then look at the fact that data is the new gold and you really want to be able to use data, there are ways to do that in a way that you can really balance the interest between that data utility and maximizing those opportunities, and at the same time making sure that that trust and the interest of the data are maintained. And if you do the exercise in that way, it is much more useful for a company, because you will also become compliant in the meanwhile, but you actually focused on the good. And you will see, because that is, for example, pharmaceutical companies, that is exactly where they're stuck on. They have this big pile of data, they want to use it for further research, but they can't, because they didn't make things at the beginning, at the collecting of the data right, because they didn't have a data governance plan. And if you have that, you can really, I think the possibilities could then be endless. And so I think when you see it like that, it is worth the while, but it is a whole other strategy.
Yeah, that's true. That's true. No, but I don't doubt. It's the same with auditing. I don't doubt what the use is, and it's the same if I do an audit. You know, it's a compliance audit. I usually also say, look, it's important for you, not for the regulator. You know, if I do GDPR, I usually also try to convince them what's in it for them, not just for the regulator. You just have to do it, but to see it in it. But what you just said, your pitch now, it should be a bit more the role, of course, of all these agencies. Now it's just more when there's a problem, but they could publish, for example, they could do more research. What you just say now, they could write an article of it and publish it on their website and saying, look, it's actually important. You have to see also if you indeed put a bit of a positive note and also the advantages, more companies would follow it. But if you just publish, look, on the website, you know, we have a ruling now, and a company has to pay 20 million euro because this is all what you find on. It's a bit with the FCA. I remember it's the same. You know, what you will see there is there are big court cases with big money. That's it. And then you're as a company still. You will still make a decision then, okay, is it worth it? The chance is very, very, very small. You could also do it differently and just say, look, if something goes wrong, is it too safeguarding? Maybe publish something, look, not with the real case, but just say, it can be interesting for you that you know this data if everything goes wrong. I find this is a bit of a missed opportunity, and why I always find it double. If you hear regulators, if I see directives coming out about DPO, it's a lot of paper, it's a lot of talk, but it's usually, it's no use for the business, you know. I do understand sometimes a lot of businesses, and it's not only small, it's also big, and even the bigger can make a better risk-based approach on it and say, okay, what is the risk for us? With this compliancy, okay, we will take it.
You know,
but you have a point, and what you just said, you know, I would hope if it indeed has a good cause and it's helping the companies, well, why don't they take this approach then? So, okay, that's it for me.
For me too. Bye.
Bye.
Thanks. Good to meet you.
Bye.
Bye.